Let's start by defining intellectual property. It's any property that is a product of an individual's mind. Some examples would include books, software, movies, and music. It goes way back to the U.S. Constitution. Constitution in Article 1, Section 8 protects intellectual property, or IP. It says Congress shall promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So it's kind of a constitutional monopoly for inventors. Ownership of IP is strategically important in the global economy. We don't deal locally that often these days. We're involved in global commerce. First type of intellectual property we'll talk about is trademarks. There's statutory protection for trademarks, including the Lanham Act of 1946 and the Trademark Dilution Act of 1995. The Lanham Act provides federal protection to manufacturers from losing business to rivals that use confusingly similar brands and products. Trademark Dilution Act of 1995 amended the Lanham Act to bring federal cause of action in federal court for trademark dilution, even when the mark is unlikely to confuse. Similar marks may give rise to a dilution suit. So it doesn't have to be exactly the same. Registration of trademarks are with the U.S. Patent and Trademark Office, or USPTO. This gives notice to third parties, and a mark can be registered if it's in use or if the mark will be used within a 6-month period. Infringement of trademarks is the unintentional or intentional substantial copying of mark. So again, it doesn't have to be complete copying, and it doesn't even have to be intentional. Courts look at the distinctiveness of the mark. Fanciful, arbitrary, or suggestive trademarks are most marks normally not related to the product. For example, Apple is really a computer, and other devices. Starbucks is coffee. This is a strong mark. Suggestive mark brings something to mind without describing the product entirely. A mark can have a secondary meaning. Descriptive, geographical, or personal names do not acquire protection until consumers associate the term with the product. For example, London fog would seem to do with weather, but it's associated with coats. Generic terms get no protection. Examples would be bicycle or computer. There's also service, certification, and collective marks. Service marks are similar to trademarks but useful or used for services. Certification mark relates to quality. Probably heard of like the Good Housekeeping seal of approval. And a collective mark is used by members of a cooperative association or union. Trade dress protects the image and appearance of a product. For example, if you think of Starbucks, you probably think of green and white, lately brown. A trade name indicates all or part of a business name that is protected. An example would be Safeway. There's also protection against counterfeiting goods. The Stop Counterfeiting and Manufactured Good Act of 2006 criminalizes intentional trafficking in counterfeit goods. One thing you do with intellectual property is license it. That means you can allow someone else to use your intellectual property, or you could use intellectual property with permission. It's an agreement that permits use of a trademark, copyright, or patent in cyberspace, or it doesn't have to be in cyberspace. Owner is the licensor and the user is the licensee, and the terms of the use are delineated in the license agreement. Looking at Cybermarks, domain names have been an issue in the past. For example, if somebody has the name Nike and someone goes online and cyber squats or gets the name Nike.com, this can prevent some conflict. ICANN is an organization that tries to prevent those conflicts and mediate those conflicts. Anti-cyber squatting legislation is laws related to Cyber squatting occurs when a third party registers a domain name that's the same or similar to another company's own trade name. And this has been turned into law in the 1999 Anti-Cyber Squatting Consumer Protection Act. There's also some attempts to draw views to a web page by including keywords and meta tags. An example is the case Playboy versus Wells. And then there can be dilution in the online world. Trademarks can be diluted on the web. For example, Candyland is a game, but I have a different meaning in case 5.2 Hasbro versus International Entertainment Group. Patents are a government monopoly that gives the inventor the exclusive right to make, use, or sell an invention for 20 years. There are a couple patent databases that are listed here. What is patentable? Items that are novel, not things that are obvious. Almost anything is patentable, excluding laws of nature, natural phenomena, abstract ideas. Things like processes, inventions, those are patentable. A patent is infringing when the manufacture, use, or sale of another's product or design is done without permission or without a license. You see this a lot, patent infringement in high-tech companies. Generally, there's not an infringement under U.S. law when a patented product is made and sold in another country. There's been a lot of disputes about patent between Apple and Samsung. Filed suit with the International Trade Commission and U.S. District Court alleging infringement of patents, trade dress, and trademarks. Those cases that went back and forth. Most recently, Apple won, and Samsung owns a large recovery. Remedies for patent infringement include injunctions or orders preventing further infringement, damages for royalties, and reimbursement for attorney fees and costs. Copyright is an intangible property right that automatically grants by federal statute to the author for a life plus 70 years. So the other things we've been talking about, required registration, copyright doesn't. If it is registered, then that does give you additional protections because it puts everyone on notice. Copyright work must be original and fixed in a durable medium. Ideas are not copyrightable, they're not protected. The expression of that idea, for example, coming out in a book, that would be protected. And there are some exclusions, and some things are copyrightable even if they're facts. Facts typically aren't, but a compilation of facts is protected. If a form or expression is copied, and it doesn't have to be in its entirety, that's infringement. Remedies would include penalties, damages, and criminal action. There is a fair use exception. Certain people, organizations can copy work without penalty. There are statutory requirements for that. For example, using it for some educational, news, or research purpose, how much of it is used, is it for profit, etc. There's a first sale doctrine, section 109A. Once a person buys or gives a copyrighted work, the original copyright holder loses control of its distribution. Modern issues in copyright include software. In 1980, which isn't that modern in these days, but Computer Software Copyright Act, which include computer programs, included computer language, binary code, structure, sequence, organization, but doesn't include the look and feel of software. Moving forward, more recently, the digital age, digital information could be copied, protection could be circumvented. Generally, anytime a party downloads software or music without authorization, that's infringement. There's a 98 DMCA and SOPA, which was recently rejected, and PIPA. These are laws that try to prevent pirating of digital information or showing someone how to circumvent the protection. MP3s and file sharing has been going on for a long time, even back to Napster and Grokster. Napster's tried to come back a few times, latest with a subscription model that failed. Basically, the idea is you share files across the network. We even have that today in cloud computing. Trade secrets are not intellectual property. They're confidential. They're not filed with the government. Could be something like a customer list, formulas, pricing. However, theft of trade secret is a federal crime under the Economic Espionage Act of '96. This could also happen in cyberspace. Theft of trade secrets through employees emailing information about, for example, a customer list to a competitor. And you don't have to memorize these laws or years that they were created. You can see case 5.3 for an example of the issues that are dealt with at an international level, but there's three major protections internationally. There's the Berne Convention, TRIPS, and the Madrid Protocol.